So Florida's bail changes are not all good news. These rule changes from Florida Supreme Court on pretrial release and bond can bring new risks for some people. Let me walk you through what you need to watch out for. If a defendant falls under certain disqualifiers like serious violent charges, they cannot be released before first appearance. And before this law change, there was some gray areas and inconsistencies across some of the jurisdictions in Florida. Now, early release disqualification is unified statewide. Now, while there's more consistency in the system, there's also less flexibility for creative solutions. Judges are now tied to a strict list of non-monetary conditions, and that means that great defense attorneys can sometimes lose the ability to craft unique release plans that are outside of the statutory box. Before these changes, judges had very broad discretion. They could impose almost any condition that they thought were reasonable. Now, judges must pick from the enumerated statutory list. Here's another big change. First appearance judges now have clear power to revoke pretrial release, even if they're not the judge assigned to your case. So even if you bonded out early, you could be sent right back into custody if the judge reviews your probable cause affidavit and revokes your release. So now first appearance isn't just about getting out of jail, it's about staying out. A good defense lawyer is always ready to fight, but now your lawyer needs to be ready to fight from day one. The clock has sped up. Under the new rule, everything happens right at the start. First appearance judge can raise your bond, add strict conditions, or even revoke release. And here's one of the biggest hidden changes. The rules about so-called dangerous crimes are now centralized in the rule of criminal procedure regarding bond and bail. There are crimes Florida law specifies as dangerous: arson, aggravated assault, child abuse, elder abuse, murder. These are just a few examples. Usually they're tied to the same list that are called forcible felonies. And these dangerous crimes themselves did not change, but the way that they can be argued about in court has been clarified under the rule. So if you're arrested under probable cause for a dangerous crime, you may not automatically get bond. And the prosecutors can seek to have you held by pretrial detention because you've committed a dangerous felony. Even with a statewide bond schedule, Florida still has 20 different judicial circuits. Each circuit can adopt its own schedule, and each judge has their own style at first appearance. For example, in Broward County, which is Fort Lauderdale, we're the 17th judicial circuit. Miami is considered the 11th, and Palm Beach is the 15th. So driving from Miami to Boca can easily put you in 3 different judicial circuits. And there will be disparities in how quickly defendants get out and what conditions they face, depending on the circuit. Some places will embrace early release and non-monetary conditions, while others are going to lean a little more conservative and really pound that money on the defendants. More than ever, having a good defense attorney ready to fight for you is invaluable in protecting your freedom. And in our next video, we're going to discuss how does all this legal change actually affect you, the client.